This is Rufus Yerxa, just to say thank you to, let's see, Alex and Toby for organizing this and for being able to do some briefing for us. Obviously, here at NFTC, and by the way, Mayor Brown is a board member of NFTC, and so we thank them for this kind of good contribution to our work process on these kinds of issues. Yeah, I mean, obviously we're very concerned. You know, we took a position when JASTA was going through the final legislative steps. Obviously that was a little like standing in front of a fast-moving train, but we still think it was the right thing to do. And now that we're dealing with it actually enacted and, you know, having to see what the future problems will be and how we can begin to develop, you know, positioning on this going forward to try to deal with adverse consequences and potential changes to it over time. So, Alex, I think, I don't know if Richard wanted to add anything, but we want to thank you all for doing this. We'll consider it sort of part of an ongoing process and food for thought for us for how we deal with this in the future.
Yeah, I'll just add, Alex, thanks again, and Toby and Alex and your colleagues there, I look forward to working with you. Well, look forward, that's maybe a tad of misplaced. We'll work together on this. Thanks so much.
Thank you. So thank you, Richard. Thank you, Rufus. My name is Alex Lukatos. I am a partner in the Washington, D.C. office of Mayor Brown. I am part of our litigation group and part of our financial services regulatory and enforcement group. I really practice around complex international litigation. We have with us here today Dan Stein, a partner in our New York office, and Toby Moffett. I'll let both of them introduce themselves.
Sure. I'm Toby Moffett, and I lead the International Global Government Affairs practice at Mayor Brown. That means that in some instances we work with countries. We happen to represent the Kingdom of Morocco in the U.S. and have done so for over 16 years. And we work with large global companies, particularly in their interaction with foreign governments. I also co-lead the Africa practice in the firm, and the Cuba co-leader of the Cuba practice. And I'm a former member of Congress from Northwest Connecticut, but also spent some time as a vice president of Monsanto Company when it was a Fortune 100 company. And in that, I have something in common with Rufus Yerxa, who leads the council and is our partner on this event.
Ed, my name is Dan Stein. I'm a partner in Mayor Brown's New York office, where I lead the firm's global regulatory and investigations practice. I joined Mayor Brown this past November when I left the U.S. Attorney's Office for the Southern District of New York. Over the years, I've spent approximately 10 years or so in that office as a federal prosecutor. Most recently, I was the chief of that office's criminal division, where I oversaw all the criminal prosecutions and investigations in that district.
Thanks, Dan. All right, so let me get right into it. I think what's useful to start things off is a little bit of background on the Anti-Terrorism Act, which is the liability landscape for civil liability for terrorism before JASTA, and that's something JASTA changed. And what was available under the Anti-Terrorism Act, as set forth on this slide here, is you could get civil liability, of course, against direct actors, your Hamas, your Al-Qaeda. You could also, plaintiffs successfully achieved liability against alleged donors and sponsors of terrorism. So that would be, for example, Islamic charities. There was also alleged, although the Saudi royal family, strenuously denies it, and I think probably with basis, that they also, aided and abetted terrorism by funding bin Laden and Al-Qaeda. A number of non-U.S. sovereign nations, to pick one, Sudan, for example, which is alleged to have provided training and financing to Al-Qaeda, and others, Iran, Iraq, Libya, under that sort of rubric of donors and sponsors. In fact, what's interesting, I think, for industry and for NFTC members is even extorted donors and sponsors have been sued. So you take a look, for example, at Chiquita Brands, and they, when they were doing business in Latin America, had to pay money to FARC because otherwise FARC would have harmed their workers. And nevertheless, they found themselves sued for aiding and abetting terrorists because of the money they provided to FARC, literally at gunpoint. As well, service providers, so airlines have been sued. United and American were both sued for allegedly being negligent and failing to prevent the 9/11 attacks. Security companies like the Massachusetts Port Authorities. Media companies, interestingly enough. So to pick an example, Al Jazeera, the Arabic television network incorporated in Qatar, was sued. The allegations were that Hezbollah, in aiming rockets in the second intifada, actually just turned on their TVs and looked at the coverage from Al Jazeera to determine where best to target the rockets, the live coverage of what was going on in Tel Aviv. So they were sued. Banks, of course, have been popular targets. To pick on one where we represented UBS, in Rothstein v. UBS, the allegations were that UBS provided physical banknotes, actual physical bills, to Iran, which then provided physical cash to Hezbollah and Hamas, which then committed terrorist attacks, and the allegations were that that made the bank liable as a service provider. So a wide variety of suits there, and what we have seen recently is that this type of suit is really on the rise. So just looking at the last 3 months, at the beginning of February, we saw a case against senior Israeli government officials, including Netanyahu, under ATA theories. In Crosby v. Twitter, we saw an action against Twitter, Facebook, and Google, essentially alleging that those organizations allowed ISIS to engage in online propaganda and therefore are liable for terrorist acts committed by ISIS. And we've seen a number of suits arising out of 9/11 that are really post-JASTA suits that we'll talk more about. But we are seeing really an influx of these. And Dan, maybe you could say to us a word or two about a criminal perspective on this and the multi-tier approach there.
Yeah, so I think the trends that Alex just highlighted in terms of civil litigation, it's important for folks to understand that this is really just one piece of a multi-pronged strategy that that the bar is pursuing. And what we see is that there really has developed in the last, 2 or 3 years, an organized bar of plaintiffs' attorneys who represent victims of terrorism, and they're pursuing all avenues to try and find assets that they can use to proceed against in order to obtain judgments and then collect on judgments. We saw in just one example, in the Southern District of New York, we settled a criminal case involving BNP Paribas, the French bank, which was a multi-billion-dollar settlement ultimately. And the same lawyers who are bringing these Anti-Terrorism Act suits made efforts in the court to recover some of those assets on the ground that they were victims of terror, that they were representing victims of terrorism, and that the basis for the criminal action against BNP involved stripping information from wire transfers to evade sanctions and thereby promote terrorism. And so therefore they argued they had a claim to these funds under the criminal forfeiture statutes. And that's still an ongoing issue. But as a general matter, the important point is to understand that the bar is pursuing criminal forfeiture, they're pursuing civil forfeiture against assets where they can, and they're pursuing these Anti-Terrorism Act cases, really all as part of one overarching strategy.
Dan, turning to our next slide, maybe you can tell us a little bit about, you know, the main statute pursuant to which these civil actions are brought, the ATA.
Yeah, so the ATA is stands for the Anti-Terrorism Act. It's a provision in the U.S. Code. It's actually in Title 18, which is the title of the U.S. Code that contains all the criminal statutes. Nonetheless, it's not a criminal statute. It's a statute that provides for a civil cause of action, and you see it on the slide here. A civil cause of action authorizing a U.S. national, which basically means a U.S. citizen, wherever that U.S. citizen happens to be located. It authorizes them, if they're injured by reason of an act of international terrorism, and the by reason of language is modeled based on the Civil RICO statute, which is another criminal statute, and it has an established meaning under the Civil RICO laws. Essentially, what that meaning is it requires there to be a proximate cause between the act of terrorism and the injury to the U.S. national. And the statute authorizes when that proximately caused injury occurs, it authorizes a civil suit. Now, just briefly, we could have a whole session on the meaning of proximate cause, but by way of overview, the concept really is one that says that the defendant is not subject to suit for anything that might be caused by anything where they could be said to be a cause for a terrorist-related injury, but rather proximate cause is an idea that says you're only liable for those effects for which your actions were a substantial factor in the sequence of reasonable causation. In other words, it's where your role in the offense or your role in causing the injury was substantial enough that a court is going to recognize it as a cause for which there should be liability. Finally, the statute authorizes treble damages, and it authorizes attorney's fees, which obviously creates a tremendous incentive to the plaintiff's bar to use this as a tool for bringing civil suits. So that's a basic overview of the Anti-Terrorism Act. Alex, do you want to walk us through some of the defenses that have been successful in responding to these cases?
Yeah, absolutely. Thanks, Dan. So most of the jurisprudence, achieving dismissal has occurred at the motion to dismiss phase, which is to say early on before discovery. Although, of course, some have gone through discovery and been dismissed later, and some have gone through even to trial. Most of the successful Anti-Terrorism Act defenses have focused mostly on the remoteness of defendants' acts and plaintiffs' injuries. So really going back to what Dan was just saying, with causation, if you take the Rothstein case, which is the case I was mentioning where Mayor Brown defended UBS, and the allegations there being that the bank gave banknotes to Iran, which gave them to Hezbollah and Hamas, which committed the acts of terrorism. And the court there said that, as a matter of causation, is simply too remote to hold the bank liable. They said, look, this is Iran giving the money. Iran is a government. It has other sources of money besides UBS. It has other legitimate sources of money, of use for the money that it gets from UBS besides terrorism, and the attackers themselves have other sources of funds. So it's simply too far removed to hold the bank liable. Another thing that courts have said is under the ATA as it previously existed, and we'll talk about how it changed under JASTA, there was no secondary liability, meaning there was no liability for aiding and abetting, and no liability for conspiracy. So that was also a remoteness sort of concept. There were lack of knowledge defenses that were also successful. So going back to the Al Jazeera case where I talked about where Hezbollah was allegedly turning on the TV and using it to aim rockets, Al Jazeera was dismissed because, among other things, it really wasn't shown to have the knowledge that its broadcasts were being used in that way. So it was, again, too remote from the injury that was going on. In addition, successful defendants and their defenses have been in the area of jurisdiction and simply saying that the U.S. courts don't have adequate jurisdiction to adjudicate these cases. So, for example, when it came to the Palestinian Liberation Organization, PLO, the court held that because the PLO is not incorporated in New York and does not have its principal place of business in New York, it can't be sued there for conduct that has nothing to do with New York. And in a case where Mayor Brown defended one of the defendants, the Tomlin case, there people tried to make some effort to link the bank to New York by suggesting that perhaps money had gone through New York correspondent accounts and eventually reached terrorism or terrorists. But they really weren't able to make those allegations, really showing that the money at issue went through New York. And without that link, the court said there really isn't jurisdiction in New York to handle these cases. Let me say just a little bit more about this causation, because that is turning out to be one of the fertile areas for dispute. And I think what's worth noting is, you know, we've talked about the UBS Rothstein case, which is a strict standard of causation. There is some indication that in the Seventh Circuit, which is the Illinois area, that there may be a more liberal standard of causation. In a case there, Boehm 3, the court talked about the idea in causation where if you have a situation where you can't tell who caused the injury, and they talked about the classic example where you have two wrongdoers who start a fire and you can't tell which of the fires destroyed the home of the innocent person. What the law will do is to find that both people are liable, and so sort of a relaxed causation in that context. And what Boehm 3 said is, you know, no person who makes a $100 donation to a terrorist group is necessarily the person who caused the terrorist act, and they aren't necessarily not that person. And so analogizing to the situation, the fire situation, everyone who donates, causation will be found. Now that may not relax causation outside of the direct donor context, but certainly it has loose language in that decision that might suggest a relaxed standard of causation in the Seventh Circuit. And so what we have been observing, including in cases where we are, retained to defend some of the defendants, is people filing in the Seventh Circuit, in fact doing so even where there's a nearly identical case already proceeding in New York, and doing so with the hope of taking advantage of what they hope will be a more relaxed causation standard out in the Illinois area. From a defense perspective, what we do is we move to transfer these cases to New York, and so that will be a fertile ground for sort of some disputes as what the proper venue is to hear these cases. Dan, I'd like to shift gears a little bit, and maybe we should talk about some of the other defenses, perhaps going to what international terrorism is and means. Would you talk about that for a moment?
Yes. Thanks, Alex. So I think just to take a step back for a moment, the important point for people to understand about this is that the term international terrorism is defined not only for the purposes of this statute for the civil lawsuits, but it's a term that has important meaning in criminal cases as well. And often, the same in the federal courts. There's no, a district judge and even a court of appeals in the federal system will hear both civil cases and criminal cases. There's no distinction between a civil court judge and a criminal court judge. And so I think it's true that the judges who are deciding the civil cases that are testing the contours of what international terrorism means are to some degree also going to be doing it with an eye towards what this means for criminal cases and whether they want to do anything that might limit the ability of the criminal authorities to bring appropriate actions against wrongdoers overseas who might be engaged in acts of international terrorism. And the term is actually defined fairly broadly. International terrorism includes activities, or it means activities that involve violent acts or acts dangerous to human life that are a violation of the criminal laws of the United States or of any state, and that are intended or appear to be intended to either intimidate or coerce a civilian population, or to influence the policy of a government by intimidation or coercion, or to affect the conduct of a government by mass destruction, assassination, or kidnapping. So basically, it's violent acts that are criminal violent acts where the goal appears to be either frightening a civilian population, or influencing government policy, or just affecting the conduct of a government. That last category is actually very broad. And finally, it's international terrorism as opposed to domestic terrorism if the acts occur primarily outside the jurisdiction of the United States or transcend national boundaries. So with that as background, Alex, do you want to turn to what JASTA is and how JASTA affects the landscape under the Anti-Terrorism Act?
Yeah, absolutely. Thank you, Dan. So JASTA was first introduced in Congress back in 2009, 2010, and it was reintroduced each year until 2016 when it was finally enacted over President Obama's veto. There have perhaps been some doubts about whether this was a good law in every way, and Toby will be speaking about that and what Congress's current thought is on it. JASTA really makes two important changes to the landscape, one that's less relevant to our audience, which is it adds a new Foreign Sovereign Immunities Act exception. Even though that's a little less relevant, it still has some relevance because to the extent that countries can be dragged in, businesses that do business with those countries also have increased exposure. And the second is that JASTA adds what's less discussed but probably more important for industry, a provision that expands the Anti-Terrorism Act by adding secondary liability, which is to say, aiding and abetting and conspiracy in certain cases. I'm going to talk briefly about the FSIA exception. Generally, I think people know, and I think all that we really need to know for purposes of this discussion, is that the Foreign Sovereign Immunities Act exempts non-U.S. governments really from two things, from litigation and from execution on their assets. And what JASTA did is it had an exception to the first one. It had an exception to allow litigation against non-U.S. governments. It was really intended to go after perhaps, or allow plaintiffs' lawyers to go after the Saudi government and perhaps the Saudi royal family, but it is worded in a way that any government really could be subject to the exception. What you need to have an exception to take advantage of the FSIA exception that JASTA creates is you need an injury in the United States. So, think 9/11 victims, that's an injury in the United States. And due to an act of international terrorism in the United States, I don't think there's any person who would dispute that the 9/11 attacks were an act of international terrorism in the United States. And then you need anywhere in the world a tortious act by a foreign government or its agents. This may sound like it's a little bit narrow, but in fact, there are other attacks, and unfortunately, there may continue to be other attacks besides 9/11 in the United States that may fit this exception, or may not, but at least give rise to argument. And I think here of a tragic nightclub shooting in Florida, which left quite a number of people dead and wounded, and the shooter self-identified as being affiliated with ISIS amongst other terrorist groups. Whether that's true, I think, could be debated, but certainly it opens the door for one to argue that this exception applies and that any non-U.S. government that can be connected to funding of ISIS could potentially be subject to a lawsuit. More relevant, I think, for this audience, although, as I said, bringing foreign governments into the ATA fold does create a window of secondary liability risk for businesses that interact with them, is the provisions that JASTA adds under secondary liability, which is to say it adds conspiracy and aiding and abetting claims. And what that requires to take advantage of those new conspiracy and aiding and abetting claims is that the act of international terrorism be committed, planned, or authorized by someone who the U.S. has designated as a foreign terrorist organization. Now, the State Department keeps a list of people who are designated as FTOs, foreign terrorist organizations. That list has about 60 names on it. It tends to be your household names, your Hezbollah, your Al-Qaeda, your ISIS or ISIL. And so that does limit the scope of secondary liability in an important way. The other thing that's interesting, you may recall earlier that I mentioned that in the UBS v. Rothstein case, the Second Circuit said, look, there is no secondary liability under the ATA. And that's precisely why JASTA needed to add it. But the fact that JASTA added secondary liability in this narrow context, which is to say for FTOs, really underscores that it was correct at the outset to say that secondary liability doesn't apply and doesn't apply now anywhere other than the narrow FTO window that JASTA creates. What's interesting, I think, perhaps, is now that you have this secondary liability, how broad really can conspiracy and aiding and abetting be? And I think, you know, Dan, as a leading federal prosecutor, probably is one of the best positions to talk about that. So, Dan, take it away, if you will.
Thanks, Alex. So, you know, the news, I think for people concerned about the scope of the ATA under JASTA, the news is not great because for some of the reasons I mentioned before about the fact that you have courts and judges who are hearing criminal cases and developing concepts that are broad for purposes of criminal liability, the same concepts are going to be applied when it comes to conspiracy and aiding and abetting in this context. And the law of conspiracy in the federal system is frankly quite broad. It requires an agreement between two or more persons to achieve an unlawful objective. And that's standard law that's existed for many, many years. And it's something that is often disputed in criminal cases where defendants claim that they didn't understand the full scope of what the conspiracy was designed to achieve, or they were only involved in small parts of the conspiracy. And those defenses in criminal cases tend to fail because the law is very well developed that to be charged with being part of a conspiracy, one doesn't need to know every detail of the criminal enterprise. One doesn't need to be involved in every aspect of the criminal enterprise. All that's required is a specific agreement to engage in the unlawful objective. Now, in these cases where you're talking about civil claims brought against commercial enterprises that provide some service to a foreign terrorist organization, the defenses are not going to be so much on the points I was just talking about in terms of not knowing every aspect of the plan or not being involved for the entire course of the conspiracy, but they really should focus on the basic idea itself that to be guilty of a conspiracy or to be responsible for a conspiracy, one needs to specifically agree with at least one other co-conspirator to engage in the unlawful objective that the conspiracy has, because it's going to be hard for plaintiffs to show that a commercial enterprise like a bank or another service provider had the specific intent to agree with the wrongdoers that are part of a foreign terrorist organization to achieve their illegal objectives. But nonetheless, because some of the law is so broadly worded, I think there's lots of opportunities for plaintiffs' lawyers to make mischief in trying to show that, trying to resist motions to dismiss and trying to take discovery in an effort to try and show that there's some agreement somewhere between their defendant and the foreign terrorist organization. Now, related to the concept of conspiracy is the concept of aiding and abetting, which is also a very well known concept in the criminal law and is very similar to conspiracy, although in some ways different. To be responsible for aiding and abetting an unlawful act, one has to know that the unlawful act is occurring, and has to take some action with a view towards seeing the unlawful act succeed. As I said, it's very similar to a conspiracy. It's often the case that people are charged both with aiding and abetting an illegal act and with conspiring to achieve an illegal objective. The two are not mutually exclusive, but in some circumstances, aiding and abetting is the more dangerous theory, and in other circumstances, the conspiracy might be the more dangerous theory. The key thing here in terms of liability under the ATA and JASTA is the requirement that to be responsible for aiding and abetting, one has to know what the illegal objective is. You know, if just to use a hypothetical from a different context, if someone asks you to give them a ride to the bank, and you agree to give them a ride to the bank, and it's only once you get there that the passenger gets out of the car and goes and robs the bank, that doesn't make the driver liable for aiding and abetting a bank robbery. It might be the case, however, if 3/4 of the way there, the passenger says, "Thanks for the ride. By the way, I didn't tell you when I got in, but my plan is to rob the bank when I get there." If the driver continues for the last portion of the ride, that might give rise to a claim that the driver was aiding and abetting, because at that point the driver knew what the person was doing. And similarly here, I think the plaintiffs are going to try and argue that you're never going to get a third party to say in writing or to testify at a deposition that they had actual knowledge that they were assisting with an act of international terrorism. But they will argue that knowledge can be inferred from reckless conduct, from the fact that the service provider is not doing adequate due diligence to try and figure out what their services are being used for, and that's enough to hold them responsible as being generally, especially if someone's dealing with a designated foreign terrorist organization, that's enough to hold someone responsible for general awareness of the nature of the third party's activity, and therefore for knowingly aiding and abetting what might be a foreign terrorist act. Alex, do you want to turn to the question of causation in this context?
Yeah, and I'll just speak about that briefly because I think, Dan, you've covered it very well. So aiding and abetting is a little different in the criminal and civil context. In the criminal context, as I understand it, causation is really not a requirement. In the civil context, it arguably is, because the assistance must be substantial. And to determine whether I substantially assisted someone, it's fair to say, well, was I a cause of their wrongdoing? As well, the ATA still has the by reason language that we discussed earlier, which really requires causation as well. I think what we should do is we should pivot now, and we should talk a little bit about where we see litigation going and where we see, various companies being at risk and how they can defend themselves. And so maybe we should talk next about trends in ATA and JASTA litigation. Dan, do you want to say a few words? All right, I don't know if I hear Dan there. In any event, that's fine. He may have his phone on mute. Here's what I would say about that. There are, I think, as Dan was saying earlier, there's a professional plaintiff's bar out there who is making a living on this. As I was mentioning at the top of the hour, we have seen, a number of new suits come. Plaintiff's lawyers are aggressive. They're creative. Suing social media is certainly an aggressive theory to say that social media is responsible for the misconduct of terrorists who communicate via social media. JASTA, I think, emboldens the plaintiff's bar. I think they view it as a win, even though there are some limitations on it. I think we'll continue to see new suits, and I think we will continue to see jousting over the exact and proper scope of JASTA. One thing that I think we've experienced on the civil side is that plaintiffs' lawyers like to follow the news. So if you have a bad news day in which somehow some product you're selling ends up being affiliated with someone who's a terrorist, even through no fault of your own, so if ISIS is frequently seen on the news driving a particular brand of new trucks, if arms and material that were sold to a third-party broker are used in an incident of terrorism, and the news media decides to take aim at the original source of those materials, that's going to be something where you could very easily see a follow-on lawsuit. I think plaintiffs view this as a variety of, number one, it gives them a roadmap of who to sue. Number two, I think that they're trying to capitalize on the sympathy for the plaintiffs and, capitalize conversely on the bad news for the defendants. There's a real tendency plaintiffs' lawyers like to kick business when it's down. And so for all of these reasons, I think, it's wise to take a look at what's happening in the news and try to govern yourself based on that, at least to some extent, because that can be a predictor of where suits will be. Dan, do you have anything you want to add on these topics?
Yes, thanks, Alex. So I think just to put a finer point on one of the points Alex was just making, the plaintiff's bar in this area has really developed into an organized bar that might be analogous to what is the case if you're talking about the asbestos bar or other areas where you have an organized bar of plaintiff's lawyers that follow developments closely, that are well schooled in the narrow areas of law that are relevant to their claims, and that really operate almost as an industry seeking out ways to bring claims and maximize the returns for their class of clients. I think the analogy to what's developing in this area is in some ways a very strong one. And you have, as we mentioned earlier, a bar that is looking for different opportunities based on the news or whatnot to capitalize on these awful acts and try to recover damages for their clients. One final point on this relating to enforcement actions is worth mentioning, which is, as I mentioned earlier with BNP Paribas, the French bank, often it's the case that in criminal actions against corporate entities are almost always resolved by means of something called a deferred prosecution agreement or a non-prosecution agreement, which are similar things. Briefly, a deferred prosecution agreement occurs when a criminal charge is filed against a corporate entity, like an indictment is filed, but the government agrees to defer prosecution of that indictment pending the fulfillment of certain conditions by the corporate defendant. A non-prosecution agreement occurs when a corporate entity is not charged, but as a condition of their not being charged criminally is they have to comply with certain conditions. Often the conditions that will be in either the DPA or the NPA include a statement of facts, and the company agrees not to contest those facts in any follow-on civil actions. When you're talking about things like money laundering or stripping of information from wire transfers or anything that might be connected in any way to a terrorist activity, those statements of facts are going to be a roadmap for plaintiff's lawyers looking to bring an ATA claim. And my experience, at least, was that while prosecutors may be aware of that circumstance, some may be and some may not be. Some companies may try to bring that to the attention of the prosecutors when they're negotiating the resolution, the final statement of facts in a DPA or an NPA. But my experience is that the reality is that even if they're aware of it, most prosecutors are not going to be terribly concerned with the idea that their settlement will have consequences for the company and follow on civil litigation. They'll tend to see that instead as, that's the company's problem. That's not the prosecutor's problem. Their role is to achieve a resolution that they consider to be fair and just under the circumstances. And if the fact is that that resolution requires the company to defend itself then against a follow-on civil lawsuit, I think most prosecutors would say, well, then so be it. So I think in terms of trends to watch in the near term, how these cases track on to enforcement actions is going to be a fertile area for the plaintiff's bar. So, Alex, do you want to talk about some of the efforts people can make to de-risk in this area?
Yeah, absolutely. Thank you, Dan. So I think, we've touched on this some already. There are some areas that are going to be higher risk for industry and that industry can consider trying to steer clear of. When we say higher risk, I think we mean higher risk of being sued, not necessarily of having the lawsuit succeed. But the lawsuits are expensive to defend. They're not guaranteed to succeed even on strong defenses because the plaintiffs tend to be very sympathetic. And the news coverage can be unfortunate and damaging, so it's best not to be sued in the first instance. So I guess the first thing that we would talk about is, supplying goods or services to state sponsors of terrorism. And here what I think is important to note is that it's not a defense that the transaction was licensed or allowed by OFAC, and it's not a defense that the transaction was licensed or allowed by your home country. It might be atmospherically helpful, or it may make the plaintiffs more likely to pick on other defendants. But the fact that you've been permitted to do this is not sufficient. So there was a time, and this is very old news at this point, but Secretary of State Kerry was going around urging various banks and even some other industries to do business with Iran in light of our trying to liberalize things there. That was not good advice to take from an ATA perspective because that's no kind of a defense. There's even been, big retailers that have self-reported on a few accidental sales in violations of U.S. sanctions and, have received attention in the media as a result. And so you can imagine, that these things are possibly things that plaintiffs' attorneys will pick up on. Perhaps they'll wait for bigger examples than a few accidental sales, but, that media coverage is out there. The next thing that I would mention, and I think I touched on this, is supplying goods or services known to be useful for terrorists. And let me give another example. Hydraulic presses, which, are necessary for all sorts of light, medium, and heavy legitimate uses, can also be used to shape charges for use in improvised explosive devices, IEDs. And so you really want to watch out, for your recipients. You may have a recipient that facially appears to be a good guy, but if they're suspected of reselling to terrorists, if they're in a transshipment point, and you don't have a sense as to who their ultimate customers are, these are areas where you ought to do a little bit more due diligence, dig a little deeper, and make sure you really understand the ultimate end user for that type of good. Another thing that I would mention is, any buying or selling of goods that are favored by foreign terrorist organizations as ready sources of cash. Now, these are things that, legitimate industries are going to be steering clear of anyway, but I would add to the list of reasons to not get involved with black market oil, with ivory, with that type of thing is the fact that, you've got middlemen, they smuggle crude oil and refined oil products from ISIS-controlled parts of Syria and Iraq to Turkey to Iran, and that's all the more reason to watch out for that type of transaction. In terms of selling arms, in terms of selling material, consider governments that are known to resell or to distribute to FTOs. Consider politically exposed persons, in those governments who may divert or allow the sale of or resale of those goods to places where you really don't want to see them go, and consider that there also could be, in addition to the other risks, an ATA, an Anti-Terrorism Act lawsuit risk. And communication services seem to be popular targets as well. We mentioned Twitter, we mentioned Google, we mentioned Facebook, we mentioned Al Jazeera. So, if you're in the business of doing cloud storage, of email, of social media, of blogs, of web hosting, you know, consider treating this with the same type of, you know, electronic scrutiny that you give to eliminate, for example, you know, abusive scenes involving children, where you just screen it out and don't let it exist on your site. So I think that's what I would say about that. In terms of high-risk counterparties, I would identify, you know, certain charities. It's over-inclusive and under-inclusive to just look at Islamic charities. We talked about FARC involved in some of these suits. But if you don't know who your charity is or where their money is going, they're a risk for you. Informal money transmission businesses, again, you know, they can be funding bad guys. You want to be careful in your dealings with them. And we talked about state sponsors of terrorism and politically exposed parties. So with that said, and with 9 minutes till the top of the hour, maybe we can turn to Toby to talk a little bit about what Congress thinks about JASTA and what they might want to do.
Thank you. So I'm going to speak from the perspective of a former member, but also someone who's worked on behalf of clients on the Hill for quite a long time. So we all know that most big issues are partisan, and there's a partisan divide. So Planned Parenthood or funding the EPA or whatever, you can see a clear partisan divide. And then there are those issues that come along every once in a while that are really motherhood and apple pie issues, where there's no partisan divide, where even a reasonably popular president can have a veto overridden and in very powerful numbers. So that's what this issue is. The only thing I could think of as a similar issue was work that I was involved in on the 9/11 health bill to provide funds for the treatment of people who got sick working on the pile at 9/11, most of them uniformed people. So that was like in the like 2005, 2006, 2007 it began and went until 2010. It took several years to get it through, and it was billions of dollars in health care, and it was, in the end, quite bipartisan and even nonpartisan. I thought about whether, if you attempted to go back and try to fix that bill, because there are some things that aren't right with it, you know, it'd be very, very hard, because you'd be accused of messing around with people going to Mount Sinai Hospital in the city and not getting treatment. But this bill, this JASTA bill, goes far beyond that in terms of difficulty of providing a fix. We've seen over decades major pieces of legislation get fixed over a period of time. I was involved with the Clean Air Act, not the original 1970, but with the drafting and passage of the Clean Air Act amendments, which are probably more important than the Clean Air Act passage itself. There could have been a fix to the affordable health care if we weren't in this political climate. Dodd-Frank, there will be fixes to Dodd-Frank, maybe pretty profound fixes, but there'll be a recognition that some parts of it aren't working, and there'll even be some bipartisan support for fixing Dodd-Frank. So how do these bills that have major flaws, that are motherhood and apple pie bills, but are overly broad and have unintended consequences, how do they get fixed? And how would this one get fixed? I have to tell you, there is no sign of any serious coalition or any movement to fix this bill. Everyone is so frightened about being seen as being against the 9/11 families. So the only way there's ever going to be a fix to this bill, because there's going to be a lot of litigation before anybody ever gets around to fixing this bill, and that's where the lawyers come in, obviously. But the only way it's going to work is that, let's just picture a room in the Capitol, some obscure room, and a very private meeting, and in that room, around that table, are Chuck Schumer, Lindsey Graham, John McCain, Corker from Tennessee, who's chairman of Foreign Relations Committee, and probably Alexander of Tennessee, because he's part of the leadership. They're going to have to come together, and Schumer will probably have some of the leadership of the 9/11 Families Coalition in the room with him, because he'd be so fearful of being seen as turning on them. And that's a very bad thing politically for a New York politician, as you can imagine. On the House side, there's no sense of, we talk to, our Republicans in the firm talk to top leadership staff. I won't mention the leaders, but you can use your imagination. Top leadership of the House of Representatives, Republican leadership. Well, first of all, there's no real New York power in that leadership. The closest thing would be Peter King, and Peter King would have to be in the room on behalf of a sort of an honest broker for 9/11 families. But, you know, the House Republican Conference does not exactly feature a lot of Northeastern Republicans, because there really aren't any. So if you're going to fix this bill, I think it's going to have to be Senate originated. I think Schumer is going to have to be the key. I think when the House comes around to eventually saying, yes, we can buy the Senate prescription for a fix, it'll be Peter King, it'll be the leadership of the House, you know, Kevin and Paul Ryan and Scalise as the whip, and probably Royce, the chairman of Foreign Affairs, Goodlatte, the chairman of Judiciary. Jerry Nadler will have to be in the room as a champion for 9/11 families in the greater New York area. But we're a long way from that. So I don't have any good news to report on that front. It's a law that's broken, that's not perfect by any stretch of the imagination, that has, you know, overly broad provisions on aiding and abetting, and is going to cause real damage to companies and possibly to other countries, and it needs to get fixed, but there's nobody willing to raise their hand and say, let's go fix it. And there won't be for some time, in my view.
And if there is a fix, will the fix, do you think, be focused on the first provision, which is the foreign sovereign immunities and helping out Saudi Arabia and other countries, or will it be focused on the second provision and helping out companies that are subject to this new broader secondary liability?
Yes, Alex, that's a good question. I mean, politically speaking, the second is what people will care about, because they'll be hearing from their companies back home, and they'll be hearing from employees of those companies. In the first, you know, this is about diplomacy and about retribution against the U.S. from other countries, and it's a little bit more of a foreign policy issue than it is about real people and real consequences.
Gotcha.
But I do think that, you know, people like you and Dan and others here and at other firms, lawyers who would have the best ideas on how to fix this, and could actually look a 9/11 family in the eye and say, this is not going against your main intention. I don't know if that's possible, by the way, but that would be for you guys to figure out. But that's what's going to have to happen here.
Right. No, I think that is consistent with what we could say. And the other thing is, you know, we talked earlier about the fact that there's a plaintiff's bar that's now become very active in this. If it gets opened up again, do you think there's a possibility that it could get fixed the wrong way, that the plaintiff's bar could try to make it even broader, and that could be a danger? Or do you think in the current...
Yeah, no, I don't think that's a real possibility.
Okay.
I mean, not with this, the leadership in the hands of the Republicans and the conservatives. I really don't think so.
Okay, excellent. All right, well, thank you, Toby. That's great. Have anything else from that perspective? All right, well, I'd like to thank everyone for joining us here today. We appreciate your time. We hope this was helpful. All of our contact information is on the PowerPoint. Feel free to reach out to us with any specific questions. We're more than happy to address them.